trust is just like an entity. It's like a shell. It's almost like you can think of it almost kind of like the same structure as like an LLC, but it accomplishes different purposes. And so a trust is like a shell that can own things. And then if it owns things, it can help you out in different ways. And so the types of trusts that we do here are normally called revocable living trusts. They probably have about 100 names throughout the United States. They're called like family trusts and land trusts and all different kinds of stuff. The important thing is that these are the types of trusts that are used in estate planning probably 90% of the time or so across the board throughout the United States. And the important thing is that they're revocable, that they're not irrevocable. And the revocability is a key factor because that's what allows people to be flexible with their trust. And so what I tell folks is that anyone who we draft a trust for, when they drive up to our office to review it and sign it into existence, whatever they could do when they drove up, they'll still be able to do when they drive out. And so you can amend it. You can put things in it. You can take things out of it. You can scrap it all together. If you decide you don't want it anymore, you can restate it. And so how this really works with kind of the trust and the flexibility is we create this trust. And then whether we're working with a single person or with spouses, we make those folks the trustees of the trust. And so these types of trusts they can really accomplish two things. They can help you avoid probate because anything that's owned by the trust when you pass away will avoid the probate process. And that's a big headache. Not only that, and then the other thing a trust can do is it can stay in existence for years and years after somebody passes away. So along those lines, you can attach strings to an inheritance. And so when one of the main reasons people go to probate is real property. If you have a house or you have land or you have mineral interests like oil rights and you haven't done anything to specifically have that piece of real property or real estate avoid the probate process, when you pass away, it's going to go through probate. What we do with a trust is we actually deed your house into your trust after you create it. And the government, the IRS, the mortgage company, all those folks are still going to look at it like you own the house. But for titling purposes and for estate planning purposes, it's titled in the name of the trust. So like for me, instead of my house being owned by Andrew St. Pierre individually, it would be owned by like the St. Pierre Family Trust. And so the advantage of that, and so well, it's kind of scary for a second, first of all, because then my house isn't in my name, but it's owned and controlled by the trust. I'm the trustee while I'm alive. So I own and control the trust that owns and controls the house. So I can still do whatever I want with the house. There's just a degree of legal separation there. And that's how the house avoids that whole court and probate process after I pass away. Because if my house is owned by my trust, what happens is when I pass away, it doesn't go and get owned by my estate and have to go through that court process. It was owned by my trust. So it just continues to be owned by my trust that still stays in existence after I pass away. Very importantly, after the initial trustees, who are our clients, pass away, the trust does lock up and it becomes irrevocable at that time. And then the successor trustees step up. So I would appoint people that I know and that I trust who would be tasked with administering the trust according to the terms that I put in there after I pass away. They can't make any changes. They can just do what I've said to do. So like they could deed the house to somebody if that's who I said I wanted it to go to, or they could sell the house if that's what I said I wanted to happen. And so the house avoids probate that way. And then the other thing is you can kind of attach strings to things. And so there's 3 common reasons that we do trusts, and we usually just go over those with folks and see if any of them apply. The first one is I usually recommend a trust to people that have like a lot of real property, especially real property like houses in multiple states, land in multiple states. And one of the reasons is you can have probate in multiple states at the same time. If I had a house in all 50 states, let's say I win the lottery and I want to just own a property in all 50 states. So I do that. If I don't do any estate planning and I pass away, there's probably going to be 50 probates. I don't even want to think about how bad that would be. If I had one trust, I could deed all of those houses into that trust, whether it was created, whatever state I'm domiciled in, you can create it there. And then no matter where you own property in the US, you can deed it into there. And it's all set up to avoid probate. So in that scenario I gave, that ridiculous example, my trust could own all 50 of those houses. When I passed away, they would all be set up to avoid probate and transfer easily outside of the court. And so that's one reason we'll do it. And And I think historically people kind of used to think, oh, if somebody has a trust, they're well off, they're wealthy, they have a lot of assets. And that is kind of the case for that reason. But the other two, which are more common, I think, at least that we see, don't have anything to do with how many assets you have. The most common reason, I think, by far that I make these trusts is for folks that want to leave to minor children. So it's lots of times parents that have minor children. If something was to happen to them, they'd want their children's inheritance to be protected. They'd want to make sure it was used to be given to their children or to benefit their children and to take care of their children. And so minors can't inherit in the state of Colorado. I don't think they can inherit in any of the 50 states. And so what ends up happening if somebody just has a will that says everything goes to our kids, or if they don't have what I tell people, if you don't have an estate plan, you actually do. The government has written one for you, and it might not say what you want it to say. And so if that's the case, it's called, passing away intestate without a plan. That usually leaves stuff to the kids as well, but they can't really inherit under the law. And so what ends up happening in those situations is kind of a disaster. The children have to go to court. There's a hearing. It can be very expensive. And then a judge who's just usually very, very bright, but at the end of the day, just a stranger in a black robe with limited information is going to make a decision and appoint a conservator. And that conservator is going to be the person that manages the children's inheritance for them under the purview of the court. The age to inherit in Colorado is 18. If you have a conservator appointed by a court like that for a minor, it changes for that individual to 21. But then at 21, they get everything outright, which isn't always the best idea. And we'll talk about that more in a second. But the idea then is that you maintain a whole lot of control. If you have to go to court and you don't know who that conservator could be, first of all, you're going to have a hearing and pay a lot of money to get that person appointed. But, and it may very well be who the parents would have wanted. It also could be somebody that the parents know very well, like the crazy uncle or somebody who they love, but they would not want managing money for the kids. If that person shows up and makes a good argument, they may get appointed. What ends up happening a whole lot is an attorney gets appointed because a judge may not know what to do. Our owner, Jeff Althaus, used to get appointed in this conservator role. He'll be the first to tell you that's kind of a disaster because then the inheritance is going to pay the attorney's fees. And so you're going to have an attorney that charges $300, $350, $400 an hour to manage this inheritance for kids. And let's say there's a 5-year-old who's lost their parents or something. That's a long time before they turn 21. You might have 5 different attorneys appointed in that role, and you'd be lucky to have anything left when they turn 21. And so the trust isn't perfect. It's never perfect if a young person loses their parents or anything like that, but it allows folks to maintain a huge element of control that they would not otherwise have, because if the trust holds the inheritance for the young person, how it works then is that they stay out of court. You don't have to go to court. The trustees, who are usually the parents, get to pick who that successor trustee would be. That's usually somebody that they know and they trust and knows the kids. And that would be the person then managing the money for the children. And then on top of that, the parents get to pick the parameters of when the children would get money and stuff like that. And that's not decided by the court either. And so again, it's not perfect, but it's a huge element of control that you get to maintain kind of in a worst case situation. And that kind of brings us into the third reason, which piggybacks off that, when going back to kind of the 21-year-old inheriting. And so I am 39, I'm turning 40 this year. And what I tell people is that I was a lot more fun to hang out with when I was 21. When I was 21, I was at the University of Tennessee. I was a junior. I was going to watch the Tennessee Volunteers play football on Saturdays. I was drinking a lot of beer. We were going out and having a great time. It would not have been a great idea for me to get a big inheritance at 21. My buddies would have absolutely loved it, but there probably wouldn't be much of that left, if any, right now when I'm 39. And so kind of to protect an inheritance from a young person from like spending it frivolously, we can attach further strings to trusts. And that's the other thing that they can do. And so lots of times we'll do we call a 25, 30, 35 distribution, where a young person would get 33% of their inheritance at age 25, the second 33% at age 30, whatever the remainder is at age 35. And you can switch up those percentages and ages to whatever you want. But the idea is that you're kind of protecting the money and protecting the young person from themselves. During that entire time, from whenever the parents were to pass away or the kids were supposed to inherit, to the time that they get their last distribution. If that's 35, there's also something on our trust called the HEM standard, and that's an acronym, and it stands for health, education, maintenance, and support. And so the trustee can always make distributions for the young person's behalf for those reasons, which basically encompasses everything: medical bills, tuition payments. If they need room and money for food, money, a place to live, they can pay for all of that stuff in their discretion. And so the idea is that the young person would always be taken care of as long as there's money in their trust fund. They just wouldn't get a lump sum into their own bank account to do whatever they want with until they reach an age that their parents would think they'd be comfortable with that. And so there's a lot of stuff there that a trust can kind of do that can really protect young people and can provide a lot of peace of mind to their parents.